Jerks. I hope you're having a good weekend. Happy Sunday. A lot's been happening. I really enjoyed being on the Grace Curley show, hosting on Friday. It's probably the last time a lot of you saw me. Just been kind of chilling out and watching all the craziness go on. May talk about it later, not too much. We don't really do drama streams on here. But we got a great guest, and that's why I wanted to come up today. And last time she was on the Grace Curley show with me, and I screwed up her Twitter handle. And then I said, you know what? I am on the way home. I just kept saying Marbury versus Mad, Marbury v Mad. I kept saying it over and over again. And then the Twitter account went away, and everyone's asking me, where is she? We're doing these FOIA requests. We want to know what's going on with the Karen Read trial, the FOIA requests that the lawsuit she's filed. They all wanted to know. And I said, well, she's coming up on the show today. She's here. Attorney Corri Hopkins, welcome back to the Young Jerks today.
Hey, Mike. Thanks for having me.
Marbury versus Matt. I got it right this time, didn't I?
You did, but I solved the problem for you and just got rid of the Twitter account altogether. You know,
No. And then I was like, I finally got it. And then she zapped it. Are
I
you
did.
coming back? Like, that's the big thing people want to know. Like, are you coming back? Are you out? What's up with Twitter?
I'll probably come back. It's just, I used to work for this attorney who once said to me, like, you seem like the type of attorney who can figure out any problem of any complexity. I'm like, ooh, I like this. Yes, keep going. He's like, you can do anything. But in order to figure out the most complex problem, you have to give something up. As in, there's like finite space in my brain now. It's like a 1-to-1 ratio. So to take in something, I have to give up something. Like most math of all complexities gone from my brain already. So when I'm, was looking at Twitter and it's just kind of, it's not fact-based or really useful, I'm like, I can't be spending my fragile brain space that's so limited on like nonsense that I don't even really understand. So get it out of my way and I can, keep doing my actual full-time job. And also suing, every other agency in the state of Massachusetts, apparently.
Great. It's I'm thinking about the same thing too. Like how much space, how much time on certain things versus like what's more important. And in Twitter too, I just feel like I spend way too much time on there considering what you get back from it, So
Exactly. For what it's worth, I feel better just generally being off of it for now. But I've got a few deadlines in a couple of the Massachusetts cases that I filed. So those are coming up at the end of October. So I'm thinking maybe then will be a good time to, share what I learned with folks.
excellent. So people are looking forward to all everything that you're doing, and you have some slides that you want to share today too, because we're talking about the Karen Read civil defense as
Yeah.
well.
Let's talk about Karen Read civil case. I'm a civil defense attorney. I have been waiting patiently for the last couple of years for, learning from all the criminal trial attorneys. I learned as much about criminal law as I needed to know to pass the bar, but that is not what I do on a daily basis. So I'm just biding my time. And now it's civil defense time. And I'm like, let's go. This is my bread and butter. Should I so I made a slide that I hope will make it easy enough to sort of, if you're a visual person, to visualize what's going on in the Karen Read lawsuit. I think no matter what, at first will be sort of blinded, but give your eyes a minute to adjust and then we'll sort of go through it, hopefully.
Should I bring that up now?
Yeah, you bring it up.
All right. The one thing I'd say too on the Karen Read civil trial is I'm excited because they let us put it on, put it on the video, put it on TV, it's going to be televised. That's very exciting to know that we're going to be able to watch this. So I'm looking forward to that, to get like, to see what's actually going on inside that courtroom.
Yeah. And you streamed the motion to dismiss hearing, right?
Yeah, that's right. We all did. We were all able to stream it.
Did they give you a hard time about that?
Not that. No. no. If if the big media does a pool camera and they get permission, everyone else gets to stream it. It's the ones where they're not doing the pool camera, and that's what's exciting about this is that everyone's going to get to stream it. There's no hoops to jump through. It's just going to be available.
Yeah, that's going to be great, and would not be the case in federal court. And I got to say, I was very surprised at the motion to dismiss hearing to hear that they were planning on filing the Karen Read on the offensive claims in state court. I was frankly shocked, but there are many reasons why it makes sense. But I was surprised. But if it was in federal court, as we know, we wouldn't get to see really any of it. We just watch the docket, pay $3 to download a bunch of documents as they get filed, and that would be that. It would be a lot less engaging.
This is about the civil trial. You made this graphic yourself, right?
Yeah, I just threw it together earlier today because I mean it's a fairly complex case in terms of the number of parties or proposed parties, and this is one way of visualizing it on a single slide. It's you can make it as complex or simple, I suppose, as you want, but I think that this kind of helps to see where we are, what sort of claims Karen Read is defending against, and what she is planning on doing as well. Sort of picture it all. And I will just explain. I've got on the left side of the screen, it's the dark blue at the top is are the 5 plaintiffs, the estate of John O'Keefe, and then his father, mother, brother, and niece. And they've asserted wrongful death claims under the wrongful death statute, and then infliction of emotional distress claims, negligent, reckless, intentional, etc. So we've got the pink claims are the pink arrows are the ones that were challenged in Karen Read's motion to dismiss. And that order just came out on Friday, I believe, at the end of the day. So I've been looking through that this week, and have you had a chance to look at it?
No. Have you?
Yeah, I read through it. I certainly read through it. It's longer than I thought potentially it would be. And I think it came out the way a lot of folks had expected, which is that not very much would get dismissed. I thought, so the only claim that actually got dismissed was the negligent infliction of emotional distress by the niece. I don't feel the need to say her name. I think we all know it, but KF. But her claim for reckless infliction of emotional distress and intentional, I believe, survived, is my recollection, and everything else survived as well. So we're going forward on all accounts. One thing that I thought was very interesting at the hearing that was just really surprising given the complaint is how much time was spent on Turtle Boy and Tully's affidavit, the search warrant affidavit from January of 2024. That was, if you look at the complaint, the allegations about, the Karen Read's alleged conduct related to infliction of emotional distress, it is, I had the complaint. It's basically one line for each cause of action. Defendant Read outrageously created a false narrative. That is pretty much the beginning and end of the allegations related to that in the complaint. So Karen Read's attorneys are going to get the complaint, whenever they got this last year, and saw that and said, oh, well, I'm going to move to dismiss the infliction of emotional distress claims because there are absolutely no facts alleging what Karen Read allegedly did. There are no facts.
Aren't you required to put that in there?
You've got to put facts in. The standard on a motion to dismiss is really low. As a civil defense attorney, I am regularly annoyed with how low the standard is. But generally, even at this sort of the lowest standard, it's essentially notice pleading, where all you have to do is just give the bare minimum. You still have to have some facts. Stating she created a false narrative does not get you there really under any standard, even the lowest standards like this one. Then we get to the motion to dismiss hearing a few weeks ago, and we have the attorney for the O'Keefes is arguing up one side and down the other about Turtle Boy and the Tully search warrant affidavit, which is bizarre to me. So looking at the Karen Read filed her motion to dismiss, the plaintiffs responded in their opposition, and in their opposition, they attached this Tully search warrant affidavit as their facts. Now, on a motion to dismiss standard, the court takes everything in the complaint as true. So everyone's bound by what's in the complaint. You can attach documents to the complaint, like a lot of times in a breach of contract case, they'll attach the contract to the complaint, and that is all stuff that the court can consider. What is very discouraged and disfavored is attaching documents to a response brief, is sort of waiting until after the defendant has filed a motion to dismiss to say, oh, but wait, I have all these additional facts that are going to help my claim survive. Well, if the defendant had those facts to begin with, they would have addressed them in the opening brief and maybe would have changed their arguments or made different ones. So I find that it wastes a lot of time and money to sort of lay in wait as the plaintiff and wait for a motion to dismiss and then bring in the facts. Now, the court can take judicial notice of facts in public filings. And that is what the plaintiffs asked the court to do here. And it's what the court did. So the court said, oh, it's a search warrant affidavit. Search warrants are presumptively public record, publicly available. Therefore, I can use those facts as well. I think, so the reason that these reckless infliction of emotional distress claims survived based on the court's opinion is all because of this Tully search warrant. It is a huge deal. Just a Monday morning quarterback, I mean, Karen Read's attorneys are phenomenal, and I'm not in any way criticizing them, and they have far more information than anyone else does. I would have very strongly considered a motion to strike the Tully affidavit as an exhibit to the plaintiff's opposition brief, because it ended up being sort of everything to keep all of these claims alive. But also, there are, normally if you attach like a court filing to a brief, for example, you're really asking the court to take notice of the fact that the filing exists, not the truth of the facts in the filing. And that's what the court did here. So I would have very strongly considered a motion to strike to make a huge deal, to see how outrageous it is that the complaint has zero facts, none. And then in the opposition brief, they attach 31 pages, single spaced, of all these very wide ranging allegations. That bothered me a great deal, that the court essentially relied on this document that, in my view, was sort of an ambush after the fact.
Sounds familiar. After the fact. A lot of stuff goes on after the fact in Norfolk County, or Plymouth County in this case, I guess.
I guess so in this case. And the other thing to draw attention to that search warrant is that's the basis for the facts, for all of her, false narrative. I would love to have put the plaintiff's attorneys on the spot a little bit more to say, what in the affidavit, though, are you pointing to as the basis for her false narrative? Because first of all, the affidavit, my read of it, alleges almost nothing that Karen Read actually did that was improper. Really nothing at all. And what it does say is that it sort of accuses her with minimal facts, if any, of disclosing information that was, protected by a federal protective order or something else. That's sort of the suggestion in the search warrant. The O'Keefe's allegations in this case are that she created a false narrative. Even if she is sharing information, she is sharing factual information. It can't be a false narrative if what you are accusing her of is sharing, say, photos that are part of this investigation. So even if the court should be able to take judicial notice of this search warrant affidavit, which I do not think the court should have, even if that's possible, it doesn't actually go towards any sort of wrongful conduct by Karen Read constituting a false narrative. They're saying it's true. I find it very bizarre. And I find that's one of the reasons why I hate this search warrant. I really do, because it's very long and it looks like it's full of facts. There are dates, there are quotes, there are things, but it's not the dates, quotes, facts that actually matter for the purpose of anything related to Karen Read, and certainly not related to this lawsuit. Smoke and mirrors, exactly. Just like mirrors. So I was looking at at the affidavit closely, just trying to figure out what could you, if I had to pinpoint like something that she is accused of having done incorrectly. And a lot of the allegations, I think, in the oral argument in the civil case were that she's controlling Turtle Boy and controlling, what he does with information, etc. Now, setting aside the absurdities of that on many levels, looking at the affidavit, there is one allegation that she controlled Turtle Boy. And what it says is Jane described one instance where Read controlled what Carney would publish. I read that and I'm like, uh-oh, here we go. This is the one. We're on page 79, almost towards the end, but we finally have something factual alleged related to her. And then it says Carney wanted to release the Kitten police cruiser video footage he had obtained from Read. Carney asked Read if he could publish it on his platform. Jane stated, Read said no. She said no. She stopped him from publishing something. So even if you believe that she controlled him based on what Tully says, all she did was tell him not to publish something. So again, if you actually comb through the facts of this affidavit, there is like shockingly nothing there. Obviously you can read it and see why the grand jury did not choose to indict on those, failed witness intimidation charges from back in early 2024, but it's just bizarre. There's no, the court didn't drill down on the facts, and I don't think that there's a factual basis in the complaint, no matter how you look at it, that supports what they are alleging she did in these emotional distress claims.
Funny too, because considering the elephant in the room that we're trying not to talk about right now, like he definitely he is not controlled by her. Like that's what everyone. I think we all know that right now. That
right?
These are two separate people. These are very two separate people. So to pretend one controls one, or neither one of these people is controlling the other. I'm just sorry. It's just like what we all know now. Come on. And like someone says, no one tells Turtle Boy what to do. That's pretty much. I mean, it's funny. It's funny with what we all know. So it's a very interesting angle they're going for.
Yeah, and it's an angle that they've adopted after they filed the complaint. I mean, this search warrant was available, I believe, at the time they filed this lawsuit in the fall of 2024. It was the search warrant was issued in January of 2024, so it existed at least, and it was actually attached to a public filing that the Commonwealth, one of their briefs that they filed in the criminal case in February of 2024. So this, is something that the O'Keeffes could have used in their complaint if they wanted to at the time they drafted it, and they didn't. I imagine they read the motion to dismiss briefing and thought, let's get some facts that the court can consider on a motion to dismiss to insert. They added the search warrant and the claim survived, which is very unfortunate. But I will say that they have now clearly made their emotional distress claims about Turtle Boy. That is, they have adopted the narrative that Tully put together in the search warrant affidavit, and based on the motion to dismiss hearing, that is going to be the factual basis for their claims, which means a lot of evidence related to Turtle Boy and perhaps his knowledge of the underlying facts and other information is going to become discoverable. It expands the scope of the litigation by bringing in additional people. Well, that is going to make it harder for the plaintiffs, the O'Keeffes, to argue now that these proposed third-party defendants cannot come in. And that is going to be I would imagine, is going to be an extremely robust battle, robust motion, robust argument to try to add these third-party defendants that were discussed at the last hearing. Which, I mean, it's, I imagine, well, it would be great if we had whatever filing they plan on filing. I imagine that the defense was not ready to submit whatever sort of motion they intended to file to bring in these third-party defendants at the time of the status conference a couple of weeks ago. The judge seemed obviously a bit annoyed with the suggestion that all of these additional parties are going to come in, but that is really nothing in comparison with how annoyed he would have been if everyone had come into town for this status conference and and Karen Read's defense was planning to bring in 10 third-party defendants and didn't tell the court at that time. So they kind of had to tell the court, but I imagine that they are not ready to put it all on paper, or were not then. And they're in a bit of a weird spot right now where everyone knows what's coming. Nobody likes it on the plaintiff or probably the court side as well, but it's coming. It's just a matter of how they're going to do it.
Now, what is the benefit of doing it that way versus just filing a regular suit against those people?
It's a good question. I imagine that it has to do with just the least sexy reason you take any sort of litigation strategic move, which is to conserve resources. If, for example, her insurance is covering the attorney's fees for the civil portion, I imagine that she would want to keep all of the litigation activity in one suit, so all of that activity is covered, depending on the terms of her policy. Also, for the same reason, first of all, having these 10 other entities and people involved in the suit means you don't have to fight as robust of a battle for discovery related to them. You can take and use depositions of these parties in the wrongful death suit as to combat obviously the allegations against her. And I think it's really mostly for efficiency purposes. Save money, save time. You're going to be deposing all the same people anyway in both cases. I personally thought that the Read team would want to get as far away from Massachusetts Superior Court as possible, just from, based on their past experiences. Of course, nothing, again, I don't know anything about Plymouth County or the judge. He seemed fantastic in the hearing. I thought he did, a great job. But I think that federal court sometimes gives you a little bit of space from any of the suggestion of, a conspiracy related to governmental conduct.
If they feel like it's not going well for them, can they still do a federal or not?
They could. The judge could deny their motion to add these third-party defendants, for example, and they could certainly file the same lawsuit that they were intending to file. They could file that in federal court. It is almost impossible to get a case from state court to federal court more than 30 days after the complaint was filed. I heard folks talk about, maybe if the McCabe's come in, they will remove it to federal court. Generally speaking, the plaintiff can file in federal court if there's a federal claim or a couple of other different circumstances. The defendant could potentially remove a case from state court to federal court within 30 days after the complaint is served. And after that, it's almost impossible to get to federal court unless something dramatic happens. And adding, say, a federal civil rights claim against third parties does not get you there. I think actually the First Circuit, which is the federal appellate court that Massachusetts is in, has not actually ruled on that issue as to whether a third-party defendant can take the case to federal court. But the majority of circuits across the country have held that you cannot, and the District of Massachusetts has held that you cannot. I think that I don't think that this case is going to ever end up in federal court if the court allows these third-party defendants to be added. And I'm very much looking forward to whatever that motion is, and I do hope that it comes with a proposed third-party complaint attached as an exhibit, which is sort of a normal practice in a lot of jurisdictions. So to say, court, this is what we want to do. That's my goal. Ooh, Next Witness. I love Next Witness. My favorite. It brings me so much joy to watch those videos.
YouTube. They have a great YouTube. Next Witness.
Have you seen it? You're on some
I
of
don't
those
think so. Am I in some of them?
Yes, it's basically a mashup of all of the lawtubers, YouTube shows, content creators, sort of going through the testimony in the Karen Read trial, and some of it, and some in the Donna Adelson trial as well. But it's like the greatest hits, the Shannon Burgess moments, the Kelly Dever. I mean, it's so good. I watched the Kelly Dever one like 10 times. It just, I love it.
I love it. I'll check it out. We've had some good YouTubers in here today. I saw uh, Bob Mata was in here earlier. I don't know if he's still watching, but the Defense Diaries. I like them too. They're great. We have a lot of good people in our audience, like quality, top notch, and it's great to see some of the law tubers are watching you right now, Corey. They love it. They're eating it up. They love the slides. You mentioned just a second ago about if they actually do this, like if how like because this judge, like you said, this judge seemed resistance on that. Like you could tell he was like, oh God, let's settle, let's settle, let's settle. Let's not bring in all these other people and make this even a bigger case. How likely is he to approve it? Like, is there a good chance he won't? Like, how does he decide whether to allow these other third parties the countersuit?
Yeah, so I looked at Massachusetts law on this issue. I litigated. I live in North Carolina. I practice in federal court a lot. I've been in a lot of different states, although I've never actually been a part of a case in Massachusetts, aside from the ones I filed in the last 2 months. But so I'm not as familiar with the Massachusetts rules of civil procedure, but they are fairly close to the federal rules. And I believe that I have to use the that they would have to use Rule 14, which is essentially the impleader rule to bring in a third party defendant. And is it possible to change the slide to the next screen? I don't know if you can see it. This is Rule 14 in Massachusetts. And just the highlighted portion at the top really says at any time after filing the lawsuit, essentially, a third-party complaint can be filed against a person who is or may be liable to him for all or part of the plaintiff's claim against him. That's what the rule says the test is. Now, I'm sure there is copious case law interpreting that phrase and as to how the judge sort of evaluates it, but that's the starting point because that's the rule that allows this third-party complaint. Sort of the general rule is the plaintiff is the master of their complaint and they get sort of deference, generally speaking, regarding where they bring the suit, who they bring it against. So you have to have a really good reason for bringing in people that the plaintiff did not include in their original complaint. And if these third parties may be liable for part of the plaintiff's claim, that is a very good reason to bring that person or persons into the lawsuit. We will see how the Massachusetts judge evaluates it. Obviously, it's a very creative argument, I suppose, that the defense attorneys have proposed here under 1983 with respect to especially the people who are in the House.
How are they?
It's creative, and I'm not sure how the judge is going to evaluate it, but I think we all saw that he would really, I suspect, he would love the opportunity to say, please take this elsewhere so we can wrap up this just easy wrongful death.
You think he wants to kick it to the feds?
Definitely. That is my personal opinion. I don't know, but that was the sense that I got, is just the groan that I saw on his face, not audibly, suggests that he would very much not like to have this whole mess, and it is going to be very messy in front of him. That said, once you bring in third-party defendants, it can inspire settlement very quickly, potentially, especially with respect to the wrongful death claims. If, for example, I obviously don't know what the O'Keefe's goals are in the lawsuit, but if they do not want to go along for the massive ride that this, 10 third-party defendant situation could be, that could be an inspiration to settle more quickly, I suppose. Also, I would say, in my experience, that when someone on the other side of the V from my client, for example, someone else in the litigation, if I represent the defendant, if there are multiple plaintiffs, when they start to not get along, it usually works out better for me. So by bringing in a group of third-party defendants that may not like each other very much at this point, that can also help inspire settlement, let's just say. And on the settlement,
Buddy, I'm laughing because I'm in a situation in a suit with two other co-defendants. So when you say that, I'm just perking things even personally. It's just funny. But
Yeah, it's
Yeah,
something
I
to
could
think
see
about.
it. I could see it. It's even, like it's funny. So, yeah, I
And
can imagine.
this second part that I've highlighted here in the Rule 14 says, okay, if you've been brought in as a third party defendant, so you say you're, Michael Proctor in this lawsuit as a third party defendant, then you can assert your counterclaims against the third party plaintiff, which would be Karen Read in this scenario, cross claims against other third party defendants. So anyone in the light blue on that chart, um, you know, those third-party defendants can assert their claims against essentially anyone already involved in the lawsuit or potentially another set of defendants, but we don't need to go that far down the road. I could see plenty of scenarios in which these third-party defendants turn on each other or other litigants. And that's what this rule allows these third-party defendants to take their own legal action.
Like who would Michael Proctor you think go after if he was? That's interesting. Like even thinking about it, like who might be most likely?
I don't know, but I sure would love to know how his relationship is with his former supervisors right now.
Kelly. Yeah, the one that we talked about the search warrant.
I mean,
Yeah, right. I mean, Tully's still got a job.
yes, as does Buchanan. Are they still buddies? They were
I know.
buddies. Their trial one, I imagine. I would love to know what their relationship is now.
Good points. This could get interesting. I mean, how long does a trial like this go for? Like it's gonna because you have so many co-defendants. If it actually went all the way, it could go on for a while, huh?
So many years. So many years. I rarely have a case resolve in a year unless a case is only going to be resolved within a year if my client wins a motion to dismiss and the case is dismissed. Otherwise, it will be years and years and years. And especially for something this complex. I can't even imagine.
Yeah, we'll see what happens with that. I mean, we'll be watching it and we'll all be eating it up. It's gonna be good to watch to see if we get more info on
We're
what
gonna
actually happened to John O'Keefe.
Yeah, we're going to get more info. And I would very much like to see, I mean, the third party complaint will be filed at some point, whether it's a standalone lawsuit or, in state court or federal court, or whether it's a third party complaint in this existing case. It's going to get filed. We are all going to eat it up and analyze it to death. And then all of those third party defendants are going to file motions to dismiss. Then everyone's going to brief and argue those. And then discovery will probably get started after that, I would imagine. It is going to be a very lengthy process. I think it will be interesting, especially if it's in state court and we can have access to the hearings.
I'm looking forward to that. That's the best news ever. When we found out that they were gonna let us that last hearing, that's when it happened. When we found out, it was like, oh my God, we can actually stream these. They're gonna let us actually stream. It was just like that's one of the best things I can say about this judge is that he made that move. I'm very glad he did that.
Yes, we definitely all are. And I think the complaint's going to be extremely complicated. The 1983 claims are so complex. I really cannot underscore that enough. Can I go to the next slide? Oh, I think I can do it.
Yep.
Okay, yeah. All right. So this is the 1980, this is the actual statute. I would not blame everyone in the audience if their eyes glaze over immediately upon seeing this on the screen. No statute really is very easy to read. However, I dug out the other day something that my law school professor in my 1983 class made for our class, which was this chart on 1983 claims. It's at least 10 years old. So if the law has been updated since then, don't hold me to it. This is what he gave it to us with no lines on the paper, just black and white. You could barely tell what was going on. I tried to make it a little bit prettier, but this is what he made for us, which I think is a pretty good visual to understand some of the complexities here. There is the 4 columns. There's a different legal standard for evaluating 1983 claims and immunities for a state defendant or prospective defendant, local government official in their official capacity, state or local officials in their personal capacities, and then state officials in their official capacity. There are totally different rules for each of those categories. So that means the town of Canton is going to have a different standard from MSP, from the individual officers. And frankly, I don't know how a 1983 claim works with non-state actors as defendants, which are the 5 individuals who were in the house. I don't know how that works. It is going to be very interesting to see, but this is sort of illustrates a bit of the complexity. Like, for example, I believe Karen Read's attorney said that the Proctor Buchanan Tully combo, those are going to be defendants in their personal capacities. So a state official or local official being sued in their personal capacity, you can get monetary relief. If you are suing a state official under 1983 in their official capacity, you can't get monetary relief. You can only get injunctive relief. And it sort of goes on down from there and complexity.
Damages. Yeah. So these cops actually could have to pay damages from their own. Is that what you're saying? Is that it's possible?
It is possible. I think it is very unlikely. I don't know how, I would think that MSP covers them even if they are being sued in their personal capacity for conduct taken, in the course of their employment. But that is going to be a battle. All these like nerdy legal battles, which I'm very excited to see unfold, are going to be, it's going to take quite a while to sort them out.
You are excited. This is like a Super Bowl for you. Like you're.
Yes, it is. I mean, I do a lot of class actions and sort of shareholder derivative litigation, sort of aggregate litigation that no one wants to talk about. I get very excited about it. But when you're talking about, federal jurisdiction, like that is my jam. How to get into federal court. A lot of times, especially class action defendants, like to be in federal court for a number of reasons. And how to get there is complex. And that is what I do all day. But it rarely comes up, especially in watching, true crime. It's all criminal. So this rarely is ever an issue. And now we're in it, and I'm excited.
In the territory that you are heavily involved in, and it's perfect. It's right in your wheelhouse, and these slides are helpful. Like the audience is loving everything you provided today. They're just so thankful. Like,
oh, good. I'm so visual.
I keep saying, I'm a visual learner. This is helpful. Yeah, they're very thankful for you.
I'm glad. I cannot, when I read like a complex case, I do a lot of litigation in Delaware. The Delaware opinions, I don't know if folks are aware, are so much longer on average than opinions from basically any other jurisdiction that I've ever practiced in. It is wild. And the complex or business organizations, the way they these like deals are structured, so complicated. So I am drawing circles, lines, arrows all over my legal pad every day just to sort of wrap my head around these concepts. I cannot do it without drawing it out. That's just how my brain works.
I'm like that too. I like that. I always have my notepads. I have notepads all over the house. Like,
yes.
I got a lot of paper. Like,
me too.
I'm a paper guy. I got a pile of paper over here, loose paper too, on top of the notepad, just in case I always need to make sure I have something to write on. So this is a question that came in. When is the next court date? Do we know that? Is there anything scheduled upcoming? It's got to be probably a while, I bet.
I imagine it would be. I imagine that the next step would be for everyone's. I don't know if there's another court date scheduled. I don't know of one off the top of my head in this case, but I recall obviously that I think everyone is waiting with bated breath to see what sort of third-party complaint or motion under Rule 14 or whatever it is coming next. There are a lot of different ways to get at this. They can file a separate suit in state court and file a motion to consolidate, or file a notice of related action, which is something you can do in federal court. There are a lot of, or they could just, in some cases, just file an answer with third-party claims in the pleading, and then put the burden on the plaintiffs to sever or dismiss the third-party complaint. There's sort of a lot of different ways to go about it, but the way the defense attorneys did it was very, we're asking the court's permission to file a motion, trying to be very sort of upfront in that regard. But asking permission to file a motion is not actually asking the court to do anything. The court's not going to do anything until you actually file a motion. And I think the judge kind of
give him the heads up, just to
Yeah.
kind of saying like, this is what our plans are, Judge. So you're not caught off guard, right? Like it's kind of a courtesy.
It was a courtesy. Obviously, the plaintiff's attorney played up very much that they were, clutched pearls, gasped. I can't believe this is happening. They know, I'm sure they knew roughly what was coming. But they're courtroom lawyers. We all play the role that you need to play.
Playing for the cameras. They were definitely trying to play for the cameras. That was interesting too. The Turtle Boy stuff. That felt to me like playing for the cameras.
I suspect that the judge is going to get very quickly annoyed with both sides doing a lot of playing to the cameras. Both sides. Very quickly, if not already fully annoyed.
Totally.
But do what you got to do for your client.
No, it's because, I mean, that's the thing. They're going to do it because everyone's watching. Kokomo says, why do all these experts think the bars will settle? What do you think, Corey? Will these bars settle? Are they the most likely to say, you know what, this isn't worth it for us? We're going to settle or not?
Yes.
Because it seems like they might have a good defense, actually, on her at least. I don't know about the other people.
The bars may have great defenses, but we've gotten past the motion to dismiss stage. And as far as I know, all of the claims against the bars are still standing, which means they're going to proceed through very expensive discovery, potentially, briefing, a motion for summary judgment, which is really like the next it's the next opportunity to get the case kicked. That is going to be months, if not years, most likely years down the road. If they want out now and to stop paying lawyers immediately, even if they have zero liability whatsoever, they will absolutely settle if it's within the scope of, something reasonable that they can afford, whatever their policy limits are. Who knows, all the different stakeholders involved on their sides. If I represented one of the bars, I would be looking to settle very quickly, just from the cost of defense perspective alone. And that's why I don't have statistics to say most cases settle, but it is a very, very, very common reason why settlements happen. Just the trouble, the business interruption, just get it off our plate.
Certainty, the uncertainty, the cost of it, the time. It's a lot. It is a lot. I mean, yeah.
It's very invasive. So there's a million reasons why any party involved in this case would settle soon if the money lines up, I suppose. I mean, in North Carolina and in most jurisdictions, early mediation before trial is required. So the parties, whether or not you want to participate, you have to go to mediation and give it the old college try, and the mediator files a report saying either all the parties participated and actually tried to settle, or potentially if, people are getting crazy and don't want to participate, then the mediator tells the court they wouldn't negotiate in good faith, and then you're going to be in huge trouble with the court. But the point is that most jurisdictions require you to try to settle, and it's completely reasonable for any party involved in this case to settle.
On that. See if I don't think Karen's going to settle. Well, you never know. I mean, the cost, but I don't feel like it. Turdad said, any developments in the court releasing sidebar transcripts from the murder trial? We did talk about this. Do you want to, just because people come in late, do you want to answer that one about the court sidebar transcripts from Karen Read?
Yeah, happy to talk about that. And we can get rid of this 1983 slide. Yeah, we've seen enough of that complexity. Yeah, so I filed 2 lawsuits, one against Massachusetts Department of Transportation. Do you call that Mass DOT or Mass DOT, or what do you call it?
DOT is what. Well, that's what I think that's what I call. I think most locals call it DOT, but
okay.
I'm sure that sometimes they do call it Mass DOT. I think I've heard it both ways, but yeah, I think most people say DOT.
Okay, I'm going to do the local thing. So DOT, great. lawsuit against DOT, lawsuit against Massachusetts State Police. Both of those cases have sort of deadlines for the agencies to either produce documents or respond to the complaint during the week of October 20th. So hopefully there will be some movement in that regard. And then is the lawsuit against Norfolk County to get copies of the sidebar transcripts, which I want so badly. And I think we all do. I mean, you just know there were so many sidebars during both criminal trials. And oh God, you just know that there's good stuff in there. I can only imagine. You know what I'm curious about is like what sidebars do people really want to see or read, I suppose. I want to see the one, where Hank asked the questions about, I believe it was to Dr. Wolf, about his employer, sort of near the end of the second trial. And I know that Alan Jackson's head exploded off of his body when he went over to that sidebar and lost for the millionth time on this FBI issue. I am dying to read that one, but I imagine there are some just incredible nuggets in there. I want to read every single page of every single one, or have someone read them to me. Anyways, still waiting on that.
I think there's going to be some YouTube channels that will be just even people have talked about professional actors reading them, and I think there's going to be a lot of entertaining moments from those sidebars on YouTube.
Yeah, Buchanan even he could hop in there potentially. We saw his acting skills at trial. It was actually fairly impressive. So we've got this. So we have Karen Read's motion in the criminal case to, I believe it's a motion for relief from the impoundment order with respect to, and it's quite a few things. It's not just the sidebar transcripts. It's the sidebar FTR audio, and I think several other things. And I think she has access to all of these things. It's just a matter of, can she use it in the civil case or in some other way? Right now, they're operating under the assumption that that all of that stuff is impounded. And some of it is. The audio, for example, I believe is still under impoundment, potentially. The audio for the sidebar transcripts. As in the FTR system, whatever that is. I think that's the Massachusetts system for audio and sidebar transcripts.
A website, basically, you pay for it, you get a copy of it. Yeah.
Okay.
And you're not, it's usually too, that's another thing. They have this system, right, that you can pay to play, to hear court audio, but then a lot of times, almost every time, it says, do not share with anybody in the public. And it's like, oh, so you got a scam here. You're charging people pay-per-view. How do they get away with this stuff where everything's privatized for profit and we suffer? We can't share it publicly. A lot of us do, but it's it sucks the way the system's set up here.
That is interesting with respect to paying for the audio. Well, the sidebar transcripts, first of all, one of Judge Cannoni's orders in between the first and second trials said that the sidebars had to be transcribed and given to counsel, which is awesome because it confirms that they exist. So it's not a situation where you have to pay the court reporter to transcribe them in the first place. They already should, at least in theory, exist. I love court reporters with all of my heart, and I am happy to pay to get transcripts normally. However, it is also nice to know that they already exist. Let's just say that, because they can get very expensive. So they should be already in the possession of Norfolk County. So I asked for these sidebars. They did not say we don't have them. They did not say they are not in our possession. They simply said they are under impoundment based on Judge Cannoni's April 14th, 2024 order. And that order is actually just allowing the Commonwealth's motion for impoundment. In that motion for impoundment, it says, by its express terms, that it expires upon jury verdict. As we all know, the jury rendered a verdict on June 18th, 2025. So I think that Karen's motion is playing it safe by asking the court, just confirm that, that this stuff is not under impoundment now. However, as we've seen, it's been sitting before Judge Cannoni for more than 2 months, possibly 3 months at this point. She filed that motion on July 30th. Court hasn't ruled on it. There doesn't appear to be any way to get the court to rule on it. And I want them. So after I've already filed these public record suits, I'm like, well, might as well keep going. The sidebars are sidebar transcripts, court proceedings transcripts are public records per se. That's from the SJC in Massachusetts. It's from the U.S. Supreme Court. It's not even a gray area. That is public record. And it's protected by the First Amendment, public access to the courts. So my argument is essentially this impoundment order that we're all worried about expired on June 18th, 2025. The transcripts are unimpounded by operation of law, automatically unimpounded. Therefore, please redact the jurors' names. I don't need to know their names. No one does. I'm more than happy for that information to be under seal until the end of time. But other than that, send them on over. And in fact, there might not be any juror names in any of these transcripts. Jurors are often referred to by their number anyway. It is very possible that there is nothing to redact. And I think that we should be able to see it. So we will see. One thing about these public record suits is the speed at which, that it takes to get anything.
It takes a while for you to file, to get your ducks in a row, but as soon as you file it, they always comply. Is that it? The speed?
Well, so far they have the other agencies have taken steps immediately to rectify their failures to respond or respond sufficiently. I think this is going to be very different because it probably involves other considerations, and I can't imagine that the agency is going to roll over and just turn them over because there are cost considerations, there are redactions considerations. It's just messier. I will say though, so when you file a normal motion in a normal lawsuit in Massachusetts, the motion is governed by Rule 9A, E, something, I can't remember which one. But we saw with Karen Read, she filed her motion to dismiss. And she just filed a notice, like a one-pager that said, notice of Karen Read's motion to dismiss, whatever. Then we didn't hear anything for months, and the parties go back and forth briefing the motions. So Karen files her, serves her motion, probably via email on the other side. They serve their response. Karen serves her reply. And all of that happens sort of out of view of the court. Months go by, then you file it all at the same time, I believe is the general practice in Massachusetts. I'm still, sort of learning these nuances. But if you file a normal motion, it will take forever to get any sort of action. The only way you're going to get anything resolved quickly is if you can file a motion for preliminary injunction. It's essentially asking the court to, like, before we get to discovery, before we do anything, please step in and take action.
Take action on this issue right now.
Right. And courts hate motions for preliminary injunction. Everyone does, except for the person filing it, because it requires you to act in a fairly, abbreviated time frame. Yeah. And but they're also very hard to get. To get a preliminary injunction before discovery, before anything, you have to show that you are likely to succeed on the merits of your claim. That is essentially like, let's do the trial at the
trial before the trial. Yeah. Yes. I used to deal with this when I was I used to run a nonprofit, and the city of Boston tried to shut down our event on free speech grounds. So every year we would go in and we would do that. We would be like, all right, we're going to file suit and just give us the permit. And the judge would say, here's your permit. City of Boston, give them the permit. We'd get that right at, and then later on, then they would have to pay our lawyer fees. Like that would come later. But that's the thing on events. Like if there's something going on with an event on a permit, you need to do that immediately. So that would always come up for us every year.
Oh, that's really interesting. So you threatened to file
the hemp fest in the Boston Common.
Got it.
Yeah.
So did you ever have to actually file the lawsuit, or did you just say we're about?
Well, they did. The ACLU lawyer would cover it. So basically, what the way it worked is, it was mostly Mayor Walsh. I don't know why he got all weird, but Mayor Menino had a few instances too. But yeah, they would always, the ACLU lawyer would show up and say, we need a preliminary injunction to get them their permit, and then we'll have our little thing, and they settle, and you'll pay. The ACLU would collect the lawyer fees, and It wouldn't cost us anything, thank God, because it's freedom of speech. This was a political issue. They were shutting our free speech down because they didn't like what we're what we were doing. So it was pretty obvious, and they would always give it to us. We'd always get that preliminary injunction, but we'd shit ourselves because a lot of times, the festival on Saturday back then. Friday night we get it, and people would be calling us all week. Do you have the permit? It's in the news. We're like, we're waiting. We're gonna get it on Friday. You watch, and we get it on Friday.
That is very stressful for a massive event.
Yeah, it was. But even if because the thing is, if we didn't get a permit, it was gonna happen anyways. People are gonna show up. We just wouldn't be able to turn on the music or have vendors. That'd be pretty much the difference. So it's funny. It never. I mean, we always ended up getting it. Thank God.
That's great.
ACLU. Thank God for the ACLU. Freedom of speech.
That's right. Well, that is essentially what gets us what should allow a preliminary injunction in the sidebars case, because it's essentially a balancing test. Are you going to win? Or are you going to suffer irreparable harm if you don't get this injunction? And how much is it going to hurt the other side? And I'm going to win because my interpretation of this court order is absolutely correct. And because it has to do with access to a court document, that implicates the First Amendment. And under Massachusetts law, thank goodness, violation of a constitutional right, including access to court records, is per se irreparable harm. So while that is always the hardest element to satisfy when it comes to a preliminary injunction, that's done. It's taken care of. It is, as a matter of law, irreparable harm. Your constitutional rights are being violated. And there's no harm to the district attorney's office because this would just be their job to comply anyway. So I'm going to win. The irreparable harm is established. No harm to the district attorney's office. Balance those factors. I think that the public should get the sidebar transcripts. And I think it should just be a matter of the scope of the redactions and if they were going to try to, get funny with the cost, which we'll save for another day.
Let's get settled quickly. What type of things do you think they would redact in the sidebars? You mentioned redaction. We did a few questions on that. Like, what are the reasons that they redact the sidebars if they do?
Aside from the juror names, which there's a number of impoundment orders that Judge Cannone has entered related to juror names, and there's a million reasons why those should be redacted. I do wonder about any discussions with respect to the FBI or whatever federal agency they're discussing. To the extent that anything is shared in a sidebar that could fall within the scope of the federal protective order, I imagine that would need to be redacted. I don't know if anything falls within that scope, but at this point, I imagine Norfolk County is very familiar with that federal protective order. That's a thorn in the side of many prosecutions going on right now. So they should know one way or the other. Other than that, I mean, then it's just sort of basic, reasonable things like medical information of perhaps a non-party that didn't come out at trial, something like that, something that would fall within the scope of HIPAA, or I don't think anyone's reading off social security numbers at a sidebar, but things like that should make sense. But beyond those things, I cannot think of something that should be under impoundment or redacted any longer.
It's going to be great to get those sidebars eventually.
So I filed my lawsuits on, I guess it was it the end of last week or the week before, whatever day it was. I guess it was 2 Fridays ago that I filed the preliminary injunction motion. So when you file a lawsuit, you file the complaint, and then in Massachusetts, the court sends you a summons, or you can go to the courthouse to get it. I obviously don't live in Massachusetts, so I had them send me one, but it takes some time. So then once I receive the summons, and it's like on fancy paper with a seal embossed in it. And then you take that and serve that with all of the filings, the complaint, whatever, on the Attorney General and the agency, Norfolk County. So I was waiting to receive the summons from the court after I'd filed everything. And the court just denied the motion for preliminary injunction, just kind of out of the blue. It was bizarre because I did the same exact order of events with the Massachusetts State Police lawsuit, and the court automatically scheduled a hearing on my motion for preliminary injunction before I had served the complaint or anything. Automatically, I didn't ask for anything. The court didn't deny it. It set the hearing date, and it was within like 10 days or 2 weeks or something like that. I'm like, great, let's, keep this moving. But the Norfolk County suit, the judge just denied the motion, which I thought was odd. In most jurisdictions, the time for the other side doesn't start until they receive service of the complaint and whatever motion. So it wasn't doing any harm. It's just sitting there until I get to serve it. Nothing can happen until then. So I'd never seen something like that before, just a denial. But it was a denial without prejudice, meaning once it's served, which it will be very, very soon, then it will be game on, and we'll see what they come back with as their arguments for why it should be kept under seal, which I do think that they're going to contest this, whereas the other agencies have not.
So they're going to contest. Wow. And will people be able to show up for these hearings? Are you going to come up here? You're in North Carolina, right?
I'm in North Carolina. I asked for a remote hearing because, time, money, full-time job, etc. But, if I will be seeking to recoup my costs, not my attorney's fees, because I'm not a practicing attorney. I'm not licensed in Massachusetts, so I'm not asking for attorney's fees, but I'm not trying to, go in the hole unnecessarily. So if it's going to take all these costs for me to litigate this lawsuit, then I will be seeking them in return on the back end. I think it would be more efficient for everyone involved to schedule a remote hearing. But we will see what the court wants to do. And if they want to do it in person, I will be there in person with bells on.
People should be able to go and show up and check that hearing out too, and maybe watch it on Zoom.
They could watch it on Zoom. If there's a Zoom hearing, I'm sure. Otherwise, open access to the courts. Water's warm. Come join me.
Definitely. You make sure you text me, or if you're not back on Twitter, let me know so I can tell everyone, because everyone's going to be looking for updates on all of this stuff, Corri.
I will. I'm not holding any of it back. I will. I want everyone to have all the information as soon as I can get it out to everybody.
Excellent. This is great. I'm so thankful you're here. I'm so thankful you're sharing everything and everything that you're doing. It's funny because I'm starting to think, like, I'm looking at some of your filings, and it's like a template for some of us to file suits, because I'm looking for in Lawrence. They're not getting back to me about the Kelsey Fitzsimmons. I'm looking for some records related to that. It didn't happen in Lawrence, but there's some records in Lawrence that I want related to Kelsey Fitzsimmons. They don't get back. They don't even respond. I got to say, Essex County DA got back to me recently, very quickly, with all the files for the Giga incident, which I thought was interesting because DA's offices are usually pretty tight. But Lawrence Police Department, not even a response to my recent FOIA request. And that happens all the time to me. Like, I'd say it's like 50% of the time they get back to you and they give you what you want. And half the time they just don't respond. They act like they never saw it. So
yeah, that's MSP never responded to any of my requests. Not late. They just never responded, aside from like a bounce back email that you get as soon as you submit it, which does not count, does not satisfy the rule. But if you're asking for documents related to Karen Read at all, and the agency denies, which they just seem to be doing, if they do respond, it generally seems to be a denial. And then you appeal to the supervisor of records. Every single appeal that I have seen related to any agency's documents related to Karen Read, the supervisor of records also denies the appeal, just on the basis of the civil suit, or they decline to, issue a decision, whatever. Either way, appealing Karen Read type documents, from what I have seen in the last couple of months, is not going to be effective. If they don't respond, an agency doesn't respond within the statutory time frame, file a lawsuit. I mean, there are templates available, not just mine, but plenty of others, depending on your factual circumstances. And if they don't respond in the statutory time frame and you file a lawsuit, they have to pay your costs and fees, or well, at a minimum, they cannot charge for actually producing the record. So they can't say it's going to be $2,000 to redact blah, blah, blah. They have to cover that cost.
Information. I hope people start filing more FOIAs, on just all across the state, in their towns and their cities, and you know, it's
Yep.
it's a good. Thank God we have some type of FOIA law. Not everyone does, right? Most places do, right? Most
I
places,
think
other
most
states have it.
I think most do. I would imagine that every state does, although they are certainly not all created equal. And I really like the Massachusetts one. I actually think it's pretty fantastic because it has a fairly short response time. Again, fees are waived if they don't respond in time, and the courts and definitely the appellate courts are really, really friendly to requesters rather than the state. Unlike almost any body of law I've ever seen. They want information to be public, and they are forcing agencies to act if it actually gets to an appellate court. So it's the case law is good. It's just filing a lawsuit can be a huge pain, which I get obviously. So I see why they that's the barrier in my mind is. But if you can get past it, if you're willing to file a lawsuit, I think that you can make things happen.
Case law here. The problem with I think with the FOIA mass, it doesn't go far enough, and who is under it. The state house exempts themselves, the governor exempts themselves. So, like local towns and cities, we can get everything basically, but you try to get your state senator his stuff, or even, I think the Mass State Police kind of falls under it, which thank God. But like the executive level, it
Hmm.
seems to kind of exempt themselves. That's why I was surprised when you went DOT. I was like, wow, I thought DOT would have been under the governor and maybe exempt, but the agencies actually are non-exempt, like the Cannabis Control Commission, the DOT, they all have to, so that's good. It's good they have the state agencies have to do it, but try to get something from the governor. You can't get anything,
I did get a
Um,
response from the attorney general when I asked for. There's a form that's supposed to be completed by DA's offices for hiring outside counsel, or the statute is not very clear, but I thought perhaps that there would be a form that would be required for Hank Brennan. So I asked the AG's office for the Hank Brennan one. They said, we don't have it. Ask the Norfolk County. But they added sort of, and also just FYI, like we have nothing to do with the Commonwealth v. Karen Read case, which I thought was a hilarious and totally unnecessary under normal circumstances addition to this letter. They could have just said, we don't have it. But they said, like, by the way, we have nothing to do with that case. I'm sure you do want to distance yourself from this bloodbath of, constitutional violations, but you know,
not my monkey, not my business. Yeah, I'm not connected.
which
Yeah,
makes me very curious as to how Norfolk County is going to wrangle in someone from the Attorney General's office with respect to the Turtle Boy cases, which it seems like what all they're left with now is to ask the AG for help. Based on the response that I got regarding Karen Read case, at least I imagine they are more than happy to say no to that.
I'm expecting that. This is going to be a stateless case. It's going to be the only chance I believe is finding another independent prosecutor, like a Hank Brennan type, a Mello. I mean, but who's going to do that? I don't know. We'll see what happens. And any final thoughts? Anything else that you want to discuss that we didn't bring up tonight, or anything you want to drill down on?
Yeah, I think we covered it. I'm very much looking forward to whatever Karen's team files in the civil case, obviously, and I'm very much looking forward to anything that's produced in response to these public records lawsuits. I very much encourage people to submit public records suit, not suits. I'm not necessarily, assess for yourself whether that's something for you, but the requests themselves. That's how people find information. There is a ton of information that we don't have. I think it would be a great idea for folks to submit public records requests. I'm still on a mission to find documents related to Kelly Dever. Their BPD is just giving me like drip, 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 a little bit at a time. But there's stuff out there that we have not obtained. I think it would be awesome if folks, try to get to the bottom of it themselves. MSP told me last week that they have 669 documents that are responsive to my request. I don't know how many of those are going to end up being black sheets of paper when they come to me, but there is stuff out there that we don't have. And I hope folks keep trying to find it.
I hope they find it. Well, I want to thank you so much for being here, Attorney Corri Hopkins. She's doing a lot of great things, covering the Karen Read civil trial, as well as filing all these FOIA requests and lawsuits and helping us get the documents, the sidebars. I want to thank you so much for being here. If anyone wants to follow up with you or reach out to you, do you have any contact that they can reach out to you right now? Or is it, we'll just wait and see if you come back, Marbury versus Mad on Twitter, hopefully?
You can always email me. My, Corri.Hopkins@gmail is my, is the email that's on all of my lawsuit filings, let's just say. So there's that. I have marburyvmad@gmail.com, but you can find me on the internet anytime. But thank you so much for having me, Mike. I really appreciate it.
I'm so glad you're here. And I want to thank you too for sticking through the technical. We had some, I don't know if people realize, but we had some technical issues with StreamYard, and Corri just kept at it. And I want to thank you for dealing with that and coming through for us. This is such a great show. People really enjoy every time you're here. And I also want to thank you for being on the Grace Curley show with me. That was so much fun. It was such a quick hit. So it's like, I didn't get to talk to you after that. And you were fantastic. You are so good on all the different platforms we have. So I'm very thankful for you. Thank you so much, Attorney Corri Hopkins, again.
Thanks, Mike. That's very kind of you. One thing I should have mentioned to you the other day was just like a fun fact. Howie Carr, I probably don't align with him on a number of issues, but I don't know if anyone knows this. He lived in Winston-Salem back in his past in North Carolina. He and my mom were reporters together at the Winston-Salem Journal in, I think, the 80s.
No way.
Oh, yeah.
You knew him back then?
Not me, my mom.
Your mom worked with Howie Carr in North Carolina. Wow.
I know. Full circle. She gets a real kick out of the fact that I've mentioned his name because it's such a blast from the past for her.
My God. Did she know how he's done since then? Like the Whitey Bulger stuff? Do you know about that?
She generally keeps up with him. Yeah. I mean, she's a news junkie like anyone else. She's a state and local reporter. So she keeps up with him.
Yeah. Because I'm just, when I go in there, I talk to him and just be in his office and we talk about all the old scandals. And he's like, do you remember this one? I'm like, yeah, I do. Like, it's unbelievable to be able to, and I'm the same way as you. Like, somebody was giving me shit this week about how I'm a fish out of water over there in some regards. But, at the same time, I'm not, because me and Howie and I, we are like this because of the local corruption coverage. So
exactly.
People can come together. It doesn't matter about your politics, and people love me on that show. Like when I'm doing that show, people are, because of the guests like you. So I want to thank you so much, Corri, for being here, being such a good guest, and we're looking forward to see what you do next.
Thank you so much, Mike. Thanks for having me.
Have a great night. And say hi to your mom too. And I might mention her to Howie. What's your mom's first name? If you don't, I want her to remember.
I'll text you.
You'll text me. Perfect. All right. Thank you so much, Attorney Corri Hopkins. Have a great rest of your weekend.
Thanks, Mike.
Thank you. She's phenomenal. Oh man, that was so good. I love that. That was such a good, quick show. It's kind of what I needed today. Some of the people in the chat, they just want to start the drama. The X wasn't enough. The drama streams weren't enough. The late night shows till 3 a.m. weren't enough. You notice I didn't do any drama streams. You notice I didn't go up, but I'm getting the shit. You got the biggest drama queen in the world starting shit with everybody, but I'm the problem. I'm sorry. I'm not going to take people's crap. I'm honestly not. I'm going to laugh my ass off, and I'm going to push back when idiots once in a while. But, mostly I just laugh because irrelevant. Look at what we do. Look at what they do. They're doing drama. That's all they do. I like when the Rogue Tony, I'm not going to get mad tonight. I'm just going to laugh my ass off. Timu guy. The Timu guy. DJ says, Mike is too busy doing it right to worry about. Exactly. I mean, I spent too much time on the drama on X today, just responding to people saying how I felt. I know JFK. I know him for a long time. I like his music. I respect what he does as a label. I respect his show. I respect he asking questions. I know it went sideways a little last night on all fronts, but I'm not on there. I'm not jumping on the show. The dude that should shut the hell up keeps going up there. And I'm the one who gets blamed for it. So, I'm sorry he has thin skin and he can't handle the truth. We went after Nick Rocco today. Went after LTL again. LTL's not saying shit. How many times can you kick LTL? And we're the drama channel. Look what we do. Look what they do. Drama, drama, drama. That's all I'm going to say about it. And some of you had to come on here and try to start shit today. And it's like, you know what? No amnesty on you. Because this has happened before. You guys, some of you guys come up here and you start crying. You start making all kinds of the rude comments. You get blocked. And then 2 months later, you're like, Mike, I love you. I'm sorry I made a mistake. Can you let me back in? You're not getting let back in. I'm not wasting my time on the people who are fair weather. I'm having no amnesty now. No amnesty. So if you start shit here, you're gone. You don't get back in. You'll have to create a new account. And yeah, drama does sell, especially if you don't have any good content. And that's why I don't have to do the drama screens. Look at the guest list that we have. So I'm happy. And again, Tuesday, Kelsey Fitzsimmons. I haven't had time to get a new phone. I wanted to stream the thing from outside. The hearing after, probably not going to happen because my phone sucks. I need to get a new phone still. It's on my list. I'm going to see the eye doctor on Wednesday. I got a family day tomorrow. I can't wait tomorrow evening. We're babysitting the grandbaby. So I have a full week. We got a lot I'm going to be working on. But Tuesday, Kelsey Fitzsimmons, 9 a.m., Essex Superior Court, Salem, Massachusetts. Be there, please. If you can, wear purple. I hope to see a lot of you there. I'm expecting to see a lot of you there. Tuesday, 9 a.m., Kelsey Fitzsimmons. Please be there if you can. Yeah, and I am entitled to my own thoughts, and I'm entitled to my own friends. You know? I like their music, man. And people, it's funny, they call them, what do they call them? They call them a washed-up rapper. The dude owns a record label that's world known worldwide, international, Static Selector. If you don't know Static Selector, you don't know hip-hop right now. If you don't know terminology, if you don't know Mac Miller, that's his label. He's making, JFK, you guys think he's broke. He don't need your money. He's got a label that friggin' he gets money on every month, royalties. He's selling shit. So that's how I know them. That's why I like them. I grew up around these people. So I'm entitled to be friends with them. I'm not backing everything they say. I'm not getting involved in the drama. I'm really not. But I think they are entitled to ask questions. And I think it's very clunky when the people that should shut the hell up keep opening their mouths and starting fights with everybody and keep self-snitching on themselves. If you're going to come clean, come clean. If you can't say something, shut the hell up. I got an incident, I don't know, a couple of years ago. Same situation some of these people are in right now. What did I do? Did I do show after show after show defending myself? I shut the hell up. So I'm giving them advice, and I'm not coddling any of the simps anymore because there are a bunch of simps. And the simps, you're making it worse for yourselves because when you come in my chat blowing it up, then I start talking about it. You don't want to hear it. You don't want reality. So why are you talking about it? Because the more you talk about it, reality is going to come out. So that's it. I'm done tonight. I'm going home. I want to thank Corri for being here. She's phenomenal. Corri Hopkins, thank you so much, attorney Corri Hopkins. She's a real great attorney down in North Carolina, and I want to thank her so much. Let me make sure I read all the super chats tonight. What the duck? Gifted 5 Young Jerks membership. Thank you so much. I love you. Thank you. You sent me a great message too this week. Thank you so much. John Miller, and that's the other thing. I am not afraid because I know I got love. I know there's going to be ride or dies for me. The lukewarm. The people that don't want to actually look into shit, you can cry and run away. But my people are sticking with me. John Miller. Thank you so much, John. And Glamour Seuss, I do have 5 notebooks going right now. I'm writing a book too. That's the thing about all this drama. I'm like, now's the time to timeline. Now the time's to write the book. Yeah, and that's the thing. I don't give a shit. I won't even watch it. Last time the dude did 3 shows on me and all he did was lose subs and my subs went up. He's got no pull. He's got no pull here. He can call me names all he wants. All I'm going to lose is the worst people in my chat. Like I'm going to lose the Fairweather fans. That's great. Get rid of them. But he's going to lose a lot more because I got the real people, and the real people know. So he can call me all the stupid names, act all tough guy, but he knows. He knows. And most of you know. And the best people know. Jermaine, thank you so much. Thank you so much. Ms. Holmes 66 says, I jumped in late, but this is one of the best shows in so long. Corey is the bomb, and Mike is amazing. Thank you so much, Ms. Holmes 66. You're great too. Oh my God, LTL, money making Mike, holding it down. Have a good show. I want to congratulate LTL too, because he took a lot of shit from a lot of shitheads. And you know what? LTL, some of the criticism was actually valid against LTL. And I think he would probably agree with that. And I think I talked to him today, and I know that he's in a good place, and he reevaluated everything, and he's making amends. And part of what he said is that he did get jealous, and he got wicked competitive. And I said to him, you know what? Everybody did, including me. Including that other asshole that goes on. He is the most competitive one of all. He's the one who always sniped us, go on 15 minutes before, did that all the time. He was the biggest crybaby. The reason we got in our first fight is because I went live 5 minutes before him. The one time I went live before him, 5 minutes before, he fucking had a nutty. The other dude, not LTL. The other dude. The simp. So LTL is doing great, and he's good at mental health, and I could see it. I could hear it in his voice today when I talked to him. Dude, I want to see you succeed. I feel like a lot of people in this local YouTube community didn't support each other, and we haven't been positive. A lot of fake bullshit going on. I'm not an actor. I'm a real person. That's why I'm not acting here. I'm not putting on skits. I'm not doing fake phone calls. I'm not doing any of this shit. I am as straight up as can be. I am Mr. Mike. This is me. There's no fakeness going on here. And LTL, he didn't have anybody. Everyone was treating him like shit. There's a reason he felt that way. And I feel like maybe I didn't do enough. And I feel guilt on it. And I feel like I'm one of the few that has actually tried to be nice to a lot of the other YouTubers. And they don't return the favors. They don't. So let's be very clear what's happened in this community. And I'm glad LTL is here. And I'm glad LTL is in my chat tonight. And LTL, I'm with you. I'm looking forward to seeing you, bro. And I want to thank Laferio, too, another one, who's gotten a lot of shit for no reason. Because she's too nice to people. And I'm sorry I didn't speak up for a lot of the women, too, who have been fucking harassed lately. Like you. There's a lot of shit that's gone on that didn't need to go on, that didn't need to be public. But these friggin' simps and their little gangs, and you're not going to do it to me because I don't give a shit. Thank you, What the Duck. Like this guy here. What is the young jerk supporting KP? Are you crazy? That lady tried to lock me up. I do not support K. Peters. I will never support. If I had to choose between LG and KP, I'm choosing LG. I'm choosing Grant Smith Ellis. You guys know I don't have a lot of love for Grant Smith Ellis. I would hang out with Grant Smith Ellis. I would have Christmas dinner with Grant Smith Ellis before I even took a phone call from KP. I would have a whole freaking dinner of Christmas with Grant before I even accepted a phone call from KP. So that's how whacked out you are, Josh. And that's the thing. Like, if you want to post that kind of shit regularly, you're out of here. That's it. I want to thank the real people here. Thank you, Weird Debbie. Thank you, Maureen. Thank you, John Miller. I want to thank all our people. Someone said preach. What is a simp? A simp is someone who is basically a follower. They don't have a mind of their own. They're just trying to get ahead. A lot of simps in this little movement. They don't actually care about each other. They'll let somebody buy them sneakers, but when that person gets dragged, they don't say shit and they actually fucking bash the crap out of them. That's what a simp is. A simp doesn't even stand up for their real friends. Simp doesn't have any friends. A simp is a simp. I'm not a simp. I don't need this shit. I love you guys. I love the chat. I love all of you, especially the ones that love me. But I don't need this. I could just step away from this, walk dogs, cut my family, my friends. I'd be good for the rest of my life. I'm on like house money. I never expected to get this far, to get 100,000 followers, 61 on YouTube and like another 40 everywhere else. If I stop now, I already did it. I hosted Grace Curley 3 times. You know what I mean? I did more than I ever wanted to do. So I don't care anymore. Like that's the thing. As a college athlete, don't get too cocky again. See, that's the thing, Mama, MSN. I'm a wrestler, and that what means you are ready to lose. The greatest wrestler of all time, Dan Gable, lost a match. Every wrestler is going to lose. There's always someone that's better. Even if you beat someone 5 times, the 6th time they may beat you because they know your style. They get in your head. They know your moves. So for me, that's why wrestling, I think, it makes you humble. You know, my senior year in high school, I was a phenomenal wrestler. Every kid I wrestled that year, even the ones I lost to, the state champs, I felt like I should have beaten them. Except one kid, Dan Kalachi. That was humbling. That was humbling, knowing no matter how good I got, I would probably never beat that kid. That's all. So for me, I'm reality based, and I know my strengths and I know my weaknesses. And I'm not an actor. Like I have no acting skills. I can't sing. That's why I love music. You know, that's why I love supporting artists, and because I can't do it, but I love it. You know, so I know me. I know my strengths and my weaknesses. I'm old enough. I didn't know in my 20s and 30s I was cocky. I was. And it cost me. But today, I am assertive, I am confident, I know my values, I know where I stand, I know who I am. You can call it cockiness, but it is what it is. I know I bring a lot to the table. I know I'm a hard worker. I know I'm not the best on the mic. I'm not smooth. I'm not so entertaining. It's a little boring sometimes until I get spicy, right? I know it all. I know all of that. But I know my value. That's all I'm saying tonight. And I'm happy. And I am happy. Yeah, either you win or you learn. Exactly. Isn't that life too? Like there was a moment in my senior year where I got scared to lose because I kept winning, and you're like, you start getting mental. Like, what if I lose? What if I lose? Then you do lose. Then it happened, and then you learn. You deal with it. And the biggest losses I'd say in my life are the greatest moments ever because it made me who I am. Losing wrestling, like when I was young, that was all I cared about. I want to be an Olympic wrestler. That was my goal. I didn't get the D1 scholarship, so I went to Bridgewater State so I could try to get a D1 scholarship, because I had gotten in trouble in the last match in high school. So like that got taken away. And every time something got taken away, it led to something else and that was writing. Like as soon as wrestling, I couldn't wrestle anymore, I started writing for the newspaper. My first media job because I lost wrestling. So every time you have a defeat, there's an opportunity there. And that's all I think about now. Every struggle, every battle, there's going to be something good that comes out of it. We just don't know it. God's got a plan for us. We don't know what the plan is. We know that sometimes with struggle, it gives us perspective, love, and all of that for later, right? And sometimes we learn a lesson. And I've had a lot of lessons. So I'm just going to be as real as I could be the real me. And I'm not taking any crap from people. I'm just not. During the Karen Read trials, that guy went on and on about me. And I just let it go because I didn't want to divide the movement. But there's one thing JFK said. He said there is no movement. And I'm seeing that. I'm seeing that. Unfortunately, it's the reality. But some people are here for the movement. And that's what my show is going to try to continue to be, about doing good things for good people. Like Tuesday, Kelsey Fitzsimmons, be there, please. 9 a.m. Essex Superior Court. I will see you there. I'll be there. If you can wear purple, the family's requesting people wear purple. And I heard from her stepdad today, and they're looking forward to seeing us all there Tuesday morning, 9 a.m. Well, that's the thing too, right? The simps gave him the clout. Since when did JFK hold so much clout? The more the bullshit went on, the more his clout went up. They poured gasoline on it. And that's not my fault. That is not my fault. And some people have respect for JFK. I'm going to go. I will see you. Yeah, that's what I want too. And if you're not here for the movement and you want to complain about drama, then go. Go watch that other guy from out of state. Is he going to cover the Karen Read civil case now? I want to know that from him. Since he's been so heavily invested, he's so friendly with the Read family. He's going to actually cover the Karen Read civil trial now. Why don't you ask him that? That's another question you could ask that guy. Since he wants to talk so much shit. I will see you on Tuesday, people. Stay peaceful. Thank you for having my back. Thank you to my mom team. I want to thank Sherry D, MJ, Jen O. I missed her last time. Thank you so much, Jen O. She's amazing. She's on point. I want to thank Stephanie. I want to thank Sarah, and I want to thank Scott McGinnis. Those are our mod team here. Thank you so much. I never found you boring. You always hit the important notes. I mean, it depends. Sometimes we can get boring over here. It's, we're talking lawyer shit. We're talking to lawyers. It's not always, like some of the other shows where it's crazy and drama and, all that shit. All right. I will see you on Tuesday morning, hopefully 9 a.m. I'm not sure if I'm going to be able to be live from there, but I'll definitely do some type of recap that night to let you all know what happened. I'm going to see that judge again. That judge is going to be there Tuesday morning. Yeah, and that's the thing. That's kind of how he earned the clout this week, didn't he? So let's be a little honest too, because I like this. Beth and Maine says it's not clout, it's respect for the willingness to have the balls to break the silence. As much balls as I had, I didn't want to have the conversation. I'm not even involved in it. They had the balls to do it. I have some level of respect for that. I'm not saying I respect everything that was said in the show, how things were handled. Things got a little static last night. I think things could have been handled a little differently. But also, hey, the guy who lost his shit the most last night had a blog put up about him again. That's probably going to affect his family and his life. So you know what? I don't blame him. I'd be pissed too. Kind of funny how the way it's working. One side pushes, the other side pushes back. It's like that's what some people want. They want to just continue it. All right, I'm headed out. I want to thank the Defense Diaries for being here and watching earlier too. We'll see you on Tuesday, hopefully. Tuesday morning, 9 a.m. Essex Superior Court, Salem, Massachusetts. Kelsey Fitzsimmons hearing. Usually it's on the third floor, I believe, the top floor. We'll see you there. Have a great night, everyone. Actually, hold on before I leave. One more thing. I keep saying I'm going to leave. I always do this, and then I forget something. I want to make sure that I'm checking out any Venmos, Cash Apps. I think I missed some last time. Just want to make sure I don't miss anybody. Maybe I got them all. Oh, no, Barbara. Barbara M. just sent $20. Now I'm hiccuping. Thank you so much, Barbara M. You rule. I really appreciate that. I think that's it. Did I miss any other ones? Hold on one second. I'm in the wrong section. I don't know if I thank Raylene H. She had recently, it looks like, given a donation as well. I want to thank her. And Judith H. That was another one that was recent too. So I want to thank everybody who kicks in and donates, supports the show, super chats, Venmos, Cash Apps. And I think that's it. I think I'm all caught up on that stuff. Yes, I am. I never want to miss. Sometimes I forget and it freaks me out. I'm like, oh my God, I forgot to thank them. And I am always wicked appreciative. Yes, the Patriots are on tonight. I'm probably going to go check that out. I'm wondering how my fantasy, it looked good early. It looks like I may not be doing so good. The fantasy. I know. I don't know, Teresa. Why do you mute the words of all sentences as a first word? I know there's a problem with this mic. I'm probably going to have to get a new mic. I've noticed that sometimes too. Yeah. That's the other thing. Karen speaks up and they I mean, how do you challenge that it's not Karen Read and it is Karen Read? And you know it's Karen Read. Certain individuals in this movement did that this week. They pretended it wasn't Karen. They knew it was Karen. They knew what it was about. They had talked to Karen. They didn't share it, but they went up on shows and told different narratives that changed throughout the week. But I'm the bad guy. The people that should shut the hell up told different narratives and poured gasoline on it. Yeah, I probably do. I'll probably get a new mic. Might get a new mic. That's probably coming next. I'll try. I'll work on that. I need a new one. Yeah, and that's the thing. I'm not taking sides. The bottom line, if Turtle Boy has any issues with me, he's gonna hit me up. He knows how to get in touch with me. I like Turtle Boy. I do. I don't always agree with everything he does. Sometimes I get mad at him and disappointed, but I do consider that we do have a friendship. And I haven't tried to I've never really leaned into that, because I don't want to be a simp. I'm not a simp. And I don't want to see him get locked up. I don't want to see him in jail. I just want to see this shit get squashed. And I want to see Karen be able to say her piece. I just wish that these two could get along. I do. Anna Long said $5 and said, don't let people get to you. Don't take sides. It gets too heavy. Some of you are in a Cardi B. Go for the gusto. Yeah, I don't care if you recognize it or not. But for me, speaking out is actually supporting Turtle Boy. Because he needs to hear it. I don't care. It's gone too far. And he knows what I'm talking about. The pouring of the gasoline doesn't help. It just makes it worse. And your simp is doing that over and over. And then you tell me I can't talk about him. I mean, we're about the First Amendment. I raised all this money for your First Amendment, but you've basically told people that we can't say his name. And he's trashing the fuck out of me in your chat. So that's where I'm just no, I'm not a simp. And I do want to get along. I want to see this shit stop. I do. And that's the thing. This was a good comment right here. Get along or do it in private. And that's the thing. Why wasn't this shit done in private? All of it. I'm not the one who went up on shows. Why didn't you try to talk to these people privately? Why did you keep going on the shows? Why did you even go on those shows? You didn't see me on those shows. You see me in those spaces? They try to get me in those spaces. They try to get me in the, I didn't go. They were asking me, Mike, come on up. We see you in the space. We see you in the chat. And I'm not even involved. And nothing I could say could really hurt anybody. Other people, the shit they're saying is not helpful. And the more the shit they say, the more it gets, especially when they're getting in beefs with people they're going to keep riding it. All right, I'm done. Have a great night, everyone. Peace out. I got the drama out. That's it. Because, people, I am not a drama channel. We're not going to do any more drama. We're not doing a drama. We're not going to do a 4-hour stream on the drama every night like other people want to do. We'll see you soon. Tuesday, Kelsey Fitzsimmons, 9 a.m. Justice. Where are my justice people at? 9 a.m. Salem. I'll see you there. Peace. Thank you so much.